Hello, everyone, and welcome to another webinar presented by EB-5 Today, we have the wonderful Jennifer Hermansky joining us from Greenberg Traurig, one of the top uh, law firms in the United States, full service firm. They cover a lot of different things, and they have been one of the pioneers in the EB-5 space. So, very excited to have you, Jen, and we'll let you introduce yourself in just a second. Very quickly, just to kind of talk a little bit about what this presentation is about. So the first thing, and probably the most important thing, is that this is not professional or legal or investment advice. This webinar is meant for informational purposes only. Everyone should please speak to an attorney that they are engaged with before making any decisions, especially when it comes to EB-5. And then a little bit of background about who we are as a company. So EB-5 has been one of the top regional centers for over a decade now, established for over 12 years. We've raised over $1 billion now in EB-5 investment funds. We've got regional centers that cover the entire United States, and we are currently running a track record with 100% success on the project side from USCIS. We've got over 30 EB-5 investment funds with hundreds of approvals across the board for our different petitions. We get investors from all over the world. We've worked with investors from all over the world and helped hundreds of families achieve their US green card dream. Our founders are Sam Silverman and Mike Schoenfeld. They, as you can see from their profiles here, they're extremely accomplished individuals with great backgrounds and pedigrees at some of the top institutions in the US and some of the top firms. Both of them came from BCG backgrounds, Boston Consulting Group, which is one of the top consulting firms in the country and the world, really. And I am Ahmed Khan. I'm the Senior Vice President here at EB-5 I have worked at several law firms over the years, just gathering knowledge everywhere that I go. I've also been an executive at multiple regional centers, so I've kind of seen both sides of the coin. And enough about us. Let's hear more about Jen and kind of her experience. Jen, if you want to just do a quick introduction about yourself and your experience, that would be fantastic.
Thanks, Ahmed. So, my name is Jen Hermansky. I'm a shareholder in the Philadelphia office of Greenberg Traurig. We are a large law firm. We now have almost 50 offices worldwide, and we have well over 2,800 attorneys, I think, at this point. So, we do a lot in the EB-5 space. We have a huge immigration team. We help to structure EB-5 projects and we do regional center compliance. We also help investors all the way through the process from the I-526 stage through a visa process at a consulate abroad or getting the 2-year green card in the US through the I-485. We also help on the I-829 petitions and even through to naturalization for those clients that want to become a US citizen. So it's very, very fulfilling for us to get all the way through a process of naturalization with our clients, and we're happy to do it. And we love this area of law. So I'm happy to be here today and talk with you about some burning questions.
Absolutely. Absolutely. Yeah. So whether you are joining us as an investor, as a regional center operator, as a prospective regional center operator or project operator, Greenberg Traurig is a great choice to speak with and engage to do the legal work. And Jen's been doing this for a long time, and she's got all the information that anyone could possibly need. So with that in mind, I think today what we're trying to talk about is a pretty key issue that's come up across a lot of and from a lot of investors over the last couple of months. And I think that we're in an age of information, but we're also in an age of kind of too much information from too many different sources. Today, investors have access to multiple different group chats, whether they're in Signal, in WhatsApp, in Discord, in all the different kind of avenues. Of course, ChatGPT is compiling all those different resources and providing their own answers. And often investors kind of, see something, kind of interpret it a certain way, and then come to us with some preconceived notions that are maybe not always correct. And one of the things that I've been hearing from a lot of investors recently has been a misunderstanding of just when their funds have to be deployed into the project. So I know that this is an area of law that has basically kind of evolved over time. So, Jen, if you want to kind of give us an idea about just generally what are the expectation that USCIS has from investors when they're investing in an EB-5 project about how long their capital should be remaining in the project overall.
Yeah, so over time, this rule has changed. And as we know, in 2022, US Congress passed the EB-5 Reform and Integrity Act of 2022. And in 2022, when they passed the RIA, they have some language that they passed in the actual law that says anyone who files an EB-5 petition on or after March 15th, 2022, the capital must be expected to remain invested for not less than 2 years. It's interesting because this was a change from what the USCIS rule was prior to March 15th, 2022. So for all of our investors that invested in EB-5 projects before the RIA, it was the long-standing rule of USCIS that those investors had to keep their EB-5 investment in a project during the 2-year period of their conditional green card. And they said that was the rule for at risk. And then when Congress passed the RIA, they said for everyone new, investing at the new investment level, so at $800,000 for a set aside project, such as the high unemployment or a rural area project, or for people investing the 1,050,000, those individuals have to keep their capital in a project for not less than 2 years. But the statute, interestingly, did not say when that 2 years should start. And so from there, we have how USCIS has been interpreting that little line in the statute. And they have some guidance in various places. So one place is they have that same language from the statute in their USCIS policy manual, which we just had up on the screen. And now USCIS also has this EB-5 questions and answers up on their website. And they tackle a number of different things on their website. But interestingly enough, this is a focus of one of the pieces of guidance under this question and answer. So, what does it mean to remain invested for at least 2 years? Well, USCIS actually, I think, took a favorable action for investors. And instead of saying that the 2 years has to coincide directly with the 2 years of the conditional green card, they've actually said that the 2 year period begins on the date that your full amount of investment money, so either 800,000 or 1,050,000, leaves the new commercial enterprise and reaches the project and the job creating entities. So once the $800,000 investment or the $1,050,000 investment gets deployed into that project, the 2 years starts. And interestingly enough, that could be well before actually the 2 year period of conditional permanent residence. So this actually represented a good change for investors for the most part because the USCIS, instead of tagging this timeline to the 2 year green card, just said it's 2 years after the project gets it and starts using the money.
Yep. It seems like they essentially decoupled the two things, whereas previously your investment timeline and the time that your money had to remain invested with the project basically was directly related to your immigration process. And for a lot of investors, especially those from China, which is extremely backlogged still to this day in the EB-5 category, this meant a really long deployment of funds, even if the first project that you invested into was complete and successful and returned the capital. Well, guess what? Now you've got to do it again multiple times to keep your money at risk per the requirements. And I think this was a big departure from kind of the previous interpretation. And like you said, it was probably the first time in a long time that USCIS has issued policy that really helped investors because this essentially did away with a lot of redeployment questions from investors, which with backlogs kind of looming once again, it's one of the first questions that investors ask is like, all right, I'm doing this, this is a lot of money for me, can I get my money back in a reasonable amount of time? And it seemed like with this interpretation, we were going to be able to do that. Now, I'm going to stay on this slide for just a second, Jen, and I know that you're very involved in the industry and kind of know of all the things going on. So we know that this interpretation was essentially challenged, not necessarily for the interpretation's reason itself, but for the way that it was implemented by USCIS from a lawsuit that was filed by IIUSA against USCIS. Can you talk a little bit about the lawsuit and kind of where we stand today in terms of the latest update?
Sure. So last year, the IIUSA organization did challenge this interpretation, and you are absolutely correct. It's not that individuals are saying that this is an incorrect way for the government to interpret it. It's just that the government hasn't followed a procedure that it should have done when interpreting the statute. So the normal thing to happen within a government agency like the USCIS is where we have a new law. After that's passed, it's time for the agency itself to write its own rules consistent with the law, and those rules we refer to as regulations. And the process is for the government to essentially, um, publish regulation and to put it out there for notice and comment to the public so that people can review what the rules might be. And we can review to see if those things are consistent with the law or to give feedback to the USCIS about how this might impact investors or other stakeholders, projects, things like that. So it's been challenged just because the USCIS just went up and put this interpretation on its website instead of going through a formal rulemaking process that it should have done. And through the IIUSA litigation, actually, the USCIS has now come forth and said to the court in that case that they are going to publish those proposed regulations in November of 2025. So it does not necessarily mean that USCIS is going to change the way they think about this 2-year rule, just that they're going to formally do the procedure that they should have done, post the prospective regulation up for notice and comment, and give people a time to comment on that. So it's, I think, possible that when we do see proposed regulations in November, the language will be following what is already up on the USCIS website.
Yeah, I think just the way that that lawsuit has gone and the declarations that were made by both parties, it seems like everyone has kind of now for lack of a better word, agreed that this is probably the interpretation that a lot of investors have relied on when filing their applications over the last couple of years. And to now change that would lead to a lot of detrimental reliance from investors and probably lead to a host of other lawsuits filed by those individual investors. And I do think that Jen and her team do have resources available for litigation as well. So if that does end up being the case, you can probably reach out to her. But fingers crossed that we actually see this guidance codified in the correct manner by USCIS by going through normal notice and comment and entering the law for investors that are filing during this RIA period, because I think it's just a huge win for investors overall. And so that's great. Now that we've kind of understood the history of this rule and how we've gotten to where we are today in terms of how long your funds need to be deployed in the project itself, we also are starting to understand a little bit about how the 829 is going to be looked at. And what USCIS is looking for when you file an 829 application, which is obviously the final step in the EB-5 process where you're asking the government to now remove the conditions on your conditional green card. Um, yeah, so Jen, if you just want to say a few words about kind of like what the that adjudication standard is based on what they've told us in their question and answers.
Right. So it also basically addresses, when can that 2-year period start? What if it happens even before the USCIS adjudicates an EB-5 petition, the I-526? So they've said that the 2-year period begins when the project receives the full amount of money from the investor, right? And they've given us a little example in the question and answers that, they've even said that the 2-year period could even be before you file the I-526 petition. And where that happens, you should continue to maintain the investment until at least the 526 is approved. That way they can appropriately evaluate eligibility. That's what they say in their guidance on the website. But it doesn't mean that the funds need to be deployed to the project during the time your I-526 is pending or immediately after the I-526 is approved. It just says that your 2-year period starts when it goes to the project. So, what does that mean? I think the rule actually hasn't changed that much for how USCIS evaluates this. Generally, it's always been the case that the funds have to be deployed to the job creating entity for the project in furtherance of job creation to create the nexus between the investment and the job creation for the project. So, we think that at this point it would be fine to deploy the funds basically at any time up through, the end of the 2-year conditional permanent residence, where you're then filing the I-829. And if the 2 years has not ended by the time you're filing the I-829, that's okay. But we should have some documentation in the I-829 petition to show that that investment will remain outstanding with the job creating entity for at least that 2-year period. Now, how would we prove to the USCIS that the money will be outstanding for at least the 2 years required? Well, through the definitive investment documents between the new commercial enterprise and the job creating entity. So, where there is a loan between those two, if the full 2 years hasn't happened yet at the time of the I-829, we would also, of course, be showing the loan agreement that the funds are still outstanding with the project and that the funds cannot be repaid and they will not, mature for at least the full 2-year period. So sometimes we might refer to this period as a lockout period in the documents where the JCE has to hold on to the money for some period of time. So generally, this has provided more flexibility for investors and also projects because it allows the project to draw down on the EB-5 funds as they actually need to pay expenses for the project. So it functions actually more sort of like a bank loan where a bank would disperse funds over time as the draw requests from the projects happen and as the construction progresses on a project. And it provides some flexibility there for the project, and it's still connected to the job creation. So we think overall this is a very good rule.
Yeah, absolutely. And I think that the main kind of point that I want investors to walk away with from this webinar and kind of this reading of the language that's very plain from USCIS and how they're interpreting this is that what USCIS has done over time is kind of say, look, as long as you are doing the things that we ask you to do with your investment, we are less worried about the time frame that you are doing those in as long as you're meeting the overall requirements. It could happen very early in your investment process. It can happen kind of in the middle of your investment process. And it may actually happen very late in your immigration process, right? So there's two different processes going on at the same time. But we're going to look at this holistically, and as long as you're making a good faith effort and the documents show that you're going to achieve the goals that you have set out to, and that we have kind of set forth the standards, you are going to be able to get not only your conditional green card, but also your permanent green card. And I like the way that you put it. It's starting to resemble a lot more like traditional loans, right? Because at the end of the day, EB-5 regional centers, for the most part, there are obviously equity investments, but I think the majority of investments that you see in the market today are going to be debt-based investments because investors just prefer that level of safety that comes with, a set maturity date and some collateralization. Um, and I think that the more that we start to look like traditional loans and the more that developers kind of start to recognize EB-5 financing as a viable option, relative to a bank, we want that to happen. We want them to look at it as more traditional financing, and we don't want to just shove money down their throat before they actually need it. That's not good for anyone because now you're giving a developer money with no line of sight on how they're going to be spending it, which is bad for the investors because they obviously want to know that as soon as their money is going in, it's being expended on EB-5 eligible costs. And it's not good for the developer because they're now starting to pay interest on money that they're not even using, and no developer wants that either. So it's a lose-lose in that situation. And I think the way that we've evolved over time, it's actually going to be good for everybody. And so to kind of just wrap this up, and I'm going to give you a hypothetical, and a lot of these conclusions you've already kind of touched on. But what's been happening a lot with, and I guess this is another good thing, is that people are getting approved very, very quickly. Just in the last few months, we've been seeing people get their 526Es in rural projects getting approved in as little as 4 months. And that's been pretty consistent. So we're in this new age of EB-5 where we really haven't had approvals as fast in the past, but people have kind of forgotten that, we've seen this before where people get approved very quickly and their funds are not yet actually in the project. And so the question has come up like, okay, I filed 4 months ago. I'm now approved. My green card is imminently arriving. But hey, the project is still keeping the funds in the NCE, and they haven't been made they haven't been made they haven't been dispersed to the JCE. They've been made available, perhaps, but they haven't been dispersed yet. Well, what's going to happen if they get dispersed 6 months from now after I've already got my green card, and then I file my 829 just a year and a half later? Am I still going to be eligible to get my permanent green card? So, Jen, I think you've actually seen this exact hypothetical play out. So, would love to hear from you and your thoughts on that.
Think the answer is yes. You absolutely are still eligible to get the green card. So, where the deployment happens sometime during the 2 year period, again, it doesn't matter any longer that it's not directly tied to the 2 years of your green card, just that the full amount of your money is deployed to the project, and thereafter it's obligated to remain with the project for at least a 2 year period and to have a connection to that job creation. So it's actually used on the construction of the project, for example. And I think this was a very conscious thing done by the USCIS because when we tied the at risk period, the 2 year period of when the money needs to be at risk risk to the green card period.
Right.
Every investor is on their own time frame. The project can't predict when that will be. Even the USCIS and the State Department can't predict when that's going to be because nobody controls the demand for EB-5. People just file, and however many people we have in line is the demand that is created for EB-5. So when we decoupled the 2-year period from the CPR period, we took away this, I want to say, it's like a period of uncertainty. We don't know when that period is going to happen. And we replaced it with something that is much easier to meet. Just that we're going to deploy it to the project when they need it. It will be used in furtherance of job creation. And then once it reaches the project, it's there for at least 2 years. It is a much more straightforward rule to benefit both the projects and the investors.
Yeah, no, I absolutely agree with that. And we've seen that kind of play out now in various different formats. And yeah, I think a lot of investors get nervous. And it's kind of funny, as a regional center representative to kind of hear all the different complaints and questions because it's like, I'm now approved too quickly. Like why is my money already in the project? And I try to let them know, like, look, we've dealt with this in the past. If you were around in EB-5 over a decade ago, you saw a lot of projects that actually didn't make funds available until much later, after investors were already approved, in fact. And some of them even had clauses that, you'd have to wait till X number of investors got their green cards before money would be given to the developer. And so we've seen all different kinds of arrangements. To your point, at the end of the day, EB-5 in the corporate world serves as an alternative form of financing, and developers will have different kinds of arrangements depending on their project needs that they are looking for. And so not every project is just going to be rote investment, funds available, go straight to the JCE. There are timelines and other factors to take into account, and developers want to plan for that and still have the flexibility to be able to meet all the EB-5 requirements as USCIS wants while still taking the money on their schedule. And I think that USCIS, based on their language, based on everything that we've heard from them over the last few years, based on this rule now being basically put into the policy manual and the questions and answers, they're aware of these different arrangements. They've seen a lot of them over the years. And I think that the idea here is, as long as you are, to your point, meeting all the job creation requirements and making sure that your funds are in the JCE for at least 2 years. And one of the things that we do, to your point, in the documentation is create a minimum hold period for all developers. So regardless of when they're taking the funds in the JCE, they have to hold on to it for at least 24 months, no matter what. They can prepay over the course. If it's a 5-year loan term, they could technically prepay in year 4, but we need them to hold it for at least year 2, or at least 2 years. And all of our developers that we work with know that. They understand that this is a big part of what EB-5 requires, and they're on board. So I think, to your point, you structure your documents a certain way to meet those requirements. You make a good faith effort to make sure the funds are readily available to the JCE and are given to the JCE in a timely manner. And timely manner can just mean as the project consumes the funds, and then you meet all the other requirements for job creation, et cetera, and you end up with a very good result for investors. Anything you want to add to that, or anything else you want to kind of add in?
Also think the USCIS did this because they know sometimes projects get delayed, right? And just because a project gets delayed doesn't mean it will never happen. Lots of things happen outside of the control of even the people that have the best intentions, right? Pretty much every project ever is dealing with municipalities and government approvals and things like that, and sometimes they get delayed. And that's outside of the control of everyone. And here again, even where delays like that happen, that might not coincide with a 2-year green card period, now it doesn't matter anymore. And so, I think again, this rule is meant to provide more flexibility for investors, and it in general is a very good rule for investors.
Yep, I agree. I think that this is the combination of kind of the 2-year requirement being decoupled from the 2-year conditional residency, and the flexibility that USCS has shown in adjudicating 829s and allowing for different arrangements as long as you're meeting the overall standards has really put investors in a good position to choose the project that they are most comfortable with. And as long as, the project is kind of moving along as expected, even if it is a little bit delayed, and let's face it, I think that everyone expects a perfect process, right? But a delayed process isn't necessarily the end of the world in EB-5. And I think that this rule specifically and the way that now it's being interpreted really does help investors understand that, like, okay, the market is really down maybe in a year, and maybe the developer doesn't want to consume capital too quickly. Well, guess what? That actually means that your money is much safer because it's still sitting in the NCE. And then if the project gets back on track and then does consume it down the road, you're still going to meet the requirements, et cetera, et cetera. But in the meantime, at least your money was in a much better place versus here's all the money, take it, just take it, do whatever you will, and hopefully this project moves on. And the developer does what they will with the funds at that point, and the investors are in a much worse position. So yeah, I think we're in a good place today with deployment standards and what that means for an 829 application that's being filed by an investor. Um, just a quick
By
plug
the
for
way, before you move on, we'll be monitoring, right, what happens with USCIS and any regulation rulemaking that happens in November.
correct.
It has been a long time coming. We've been waiting since March of 2022 for the USCIS to come out with some rules. But if there are any changes to this rules or developments, of course, we would, be addressing those again in the future. But for now, everything is the same.
Yeah, we're going to bring Jen back on specifically to talk about the November guidance once we see what it looks like and what USCIS has in mind. But yeah, just based on their representations in the lawsuit, and then obviously the headache that they would face if they went in a different way, the expectation I think across the industry is we're going to see something very similar to what we've already seen from them back in 2023. So yeah, if you're looking for a good project that meets all the requirements that we just talked about, we have several different projects available. We've got three in the rural TEA, and we've also got three different offerings in the urban TEA. On the rural side, we've got a great project out in Virginia called Bay Creek. It's a shorter, kind of 5-year maximum loan term with a senior mortgage. And this project actually and in the Grand Park project that's kind of next to it, you can see funds are actually consumed very, very quickly. But Rocky River, which is in the middle here, is actually one of the projects that has led to a lot of these questions because we build in a little bit of a drawdown delay for the developer. And by delay, it's really just we know that we have line of sight on how the developer uses these funds. We've worked with Coulter for several years now, over a decade, and they've never failed to use the funds. The projects are moving along as expected. But if you're building 1,000 home community, you're not building all 1,000 homes at once. You're building them 10 at a time every month. And so Coulter draws very continuously and kind of predictably every month. And it takes them, usually about a year or so in this fund to use the funds and put them into the project, which still aligns with investors' overall goals and to help them get their conditional and permanent green card. So this is the project that a lot of investors have the question on. And so if you were confused, hopefully now you've gotten some clarity and you can choose that as an option. And if you're more interested in urban TEA projects, we've got a few great options there as well. Two loan products also with Coulter. Um, Fairly short terms. All of our projects are currently under construction. And if you're looking for a high return ROI project, we've got an equity option in our Terracea project as well. So just a quick plug there. We've got a lot of different options. If you're looking for EB-5 investment, always happy to help. Um, Jen, thank you so much for joining us today. That was a great legal analysis. I know both of us are at heart immigration nerds, and we like to dig down deep into the weeds and kind of help investors out. But I do think that we're kind of in a great era of EB-5 where rules have become a little bit more clear, and USCIS for once has actually helped investors out with a better reading of those rules. So thank you so much for helping clear that up. And if anyone has any questions or wants to reach out to Jen individually, her contact details are on the screen. She loves hearing from EB-5 investors. She does it every day. And I encourage you to reach out to her and engage with GT for your needs.
Thank
Jen,
you
any
so much
parting
for having
words?
me. Yeah, thank you so much for having me today. Happy to answer any questions that individuals have about their immigration process or timelines. And again, we will stay up to date with EB-5AN on what happens at the end of November. So stay
Awesome.
tuned.
Yep. Awesome. All right. Thanks, everyone. And this concludes the webinar, and hopefully we'll hear from everyone soon.